Well, hello, everyone. Welcome to our webinar today. I'm Tracy O'Brien. I'm an attorney in Husch Blackwell's Healthcare, Life Sciences, and Education Group. My practice focuses on assisting federal contractors, including healthcare, life science, and education clients, in compliance with employment laws and regulations. Specifically, I defend clients against in audits with the OFCCP, as well as in claims of discrimination, harassment, and retaliation, and other related claims before administrative agencies and federal courts. Before we begin, I'd like to cover a few housekeeping items as usual. At the bottom of your audience console, there are multiple application icons for your use during our program today. If you have any questions during the webcast, please submit via that question box. We will then try to answer all the questions during the webcast today. However, if a fuller answer is required or perhaps we run out of time, we'll answer it later via an email. A PDF of the presentation is also available in the program materials folder. This program has been approved for legal education hours. For live attendees, you will report your hours by clicking on that CEU icon at the bottom of the screen. A certificate of attendance, including the course numbers, will be emailed to you tomorrow, along with you will also receive a recording of the webcast for watching and for sharing. Toward the end of the program, be sure to complete our short survey. We appreciate the feedback. It helps us plan for future programs that are applicable to your business needs. So that's all for our housekeeping items today. Let's get started with our program. I am happy today to join my colleague from California, Tyler Patko. Tyler is a partner in our labor and employment group. He's a California-based litigator. He has represented employers in labor and employment law matters for over 30 years. As both a trusted advisor and a litigator, Tyler handles a variety of labor and employment challenges, including claims of wrongful termination, discrimination, retaliation, sexual harassment, defamation, wage and hour violations, unpaid commissions, collective and class actions, and unfair labor practice charges. He also has an extensive experience representing employers in traditional union management labor relations matters, including union organizing campaigns, strikes, and collective bargaining negotiations. Okay, we are going to present our agenda first. Tyler will start us off discussing the California pay reporting and transparency laws and some recent developments, including some developments that appeared lately in the California CRD FAQs. I will then update you on what remains a key priority for the Office of Federal Contract Compliance Programs, or the OFCCP, which is to ensure that federal contractors are complying with their compliance obligations with regard to compensation practices. I will also go over their most recent interpretation of their regulation regarding compensation practices. We will wrap up our webinar with Tyler discussing some best practices to implement when you are conducting your own internal pay analysis and how to maintain privilege. Okay, Tyler, I'll let you move the slides for your presentation. You can take it over.
Great. Thank you, Tracy. And thank you, everyone, for joining us. Tracy's really the expert here in terms of pay audits, but California relatively recently joined the federal contractors out there with an emphasis on pay transparency, pay equity. And just to kind of set the stage here and why we're even talking about pay transparency, California, when it passed Senate Bill 973 there, which is in the California Government Code 12999, set forth the legislative purpose behind the pay transparency reporting law, pay data law. And the legislature found that, not surprisingly, despite California's effort to strengthen equal pay laws, the gender pay gap persists. resulting in billions of dollars in lost wages for women each year in California. Pay discrimination is not just a women's issue, but also harms families and the state's economy. In California in 2016, women working full-time year-round made a median 88 cents to every dollar earned by men. And for women of color, that gap is far worse. The legislature went on to say, although there are legitimate and lawful reasons for paying some employees more than others, which we'll talk about in this program, pay discrimination continues to exist, is often hidden from sight, and can be the result of unconscious biases or historic inequities. So we're here, it's 2024, that ain't right. And whether you're a man or a woman, not getting paid the same for doing the same job is not good. It's not right. It's not just. So this is a well-purposed law. The devil's, of course, is in the details. In California, we have this trifecta of laws: the Pay Transparency Act, Senate Bill 1162, codified in the Labor Code. And it's a little bit confusing for those, especially outside of California. Why do they have so many laws in the Labor Code, and then we got to go to the government code for other laws? So welcome to California. So the Labor Code details that Pay Transparency Act. Senate Bill 973, which I mentioned earlier, is really the key law on annual pay data reporting. And then we also have had for a while the California Equal Pay Act, which requires equal pay for substantially similar work. So that's kind of the law in terms of the existing laws that are out there in California. And just starting with the Pay Transparency Law, became effective January 1, 2023, so over a year ago. It applies to both applicants and employees, applies to employers with 15 or more employees, so it's not 100 or more, as the pay data reporting law requires. And it requires a pay scale for any position in an internal, external job posting, including on third-party platforms. And to be covered by this pay transparency law, an employer need only have one employee in California. So you could have 1,000 employees across the country, but if you have one in California, this law is triggered, as well as the pay data reporting law. The pay scale must be included within the job posting for any position filled in California, either in person or remotely. Hybrid workers, at least the government treats them as in-person workers, at least under the pay reporting laws. There's also enhanced record-keeping requirements under this law, the duration of employment plus 3 years. I would also note, under the separate pay data reporting law, the frequently asked questions, FAQs, they say it should be 10 years. Employers should keep records for 10 years. So I read that last night. I was a little bit surprised. So that is the pay transparency law. The idea here, as the legislative history and legislative purpose indicates, is they want to make sure that employees know if they're getting paid fairly and to make it public. It's a bit of an oddity because most of us don't want to publicize our compensation. We view it as private. In California, an employer can't ask an applicant about prior salary. That is viewed as potentially discriminatory. California also has a law that says you can't prevent an employee from discussing their wages. That's also protected under the National Labor Relations Act. So we have this tension between privacy on the one hand and all of this push and momentum to be transparent in compensation data. The pay scale, this is under the Division of Labor Standards Enforcement, also called the Labor Commissioner in California. Department of Industrial Relations defines pay scale as the salary or hourly wage the employer reasonably expects to pay for a given position. It must include piece and commission rate if it would affect the hourly wage. So the posting requires other compensation and benefits, and it must be included, that pay scale, within the job posting and not linked to a QR code, sorry. About 5 years ago, I didn't know what a QR code was, but there you have it. Let me now go to the major law here that we're dealing with California employers, and that's the data reporting law. One thing I should note is that the deadline for 2023 calendar year for reporting, the 2023 reporting deadline was May 8, 2024. So Tracy and I did one of these programs before that deadline, and we didn't get the question, but I expect that some of you might have the question, what if we didn't submit our pay data and we're covered, we have to report by May 8 of this year, which is now several weeks ago. Tracy, what are your thoughts if an employer just misses the deadline? They got too many things going on. They didn't understand that California has this new requirement.
Yeah, well, we recommend that you submit as soon as you can. It's better to have submitted and even if it's late, then not have submitted at all. What do you think, Tyler?
I'm kind of in agreement. Reading the FAQs, and a little spoiler alert for the audience. If any of you are doing these pay reporting reports or audits, I would strongly encourage you to read the FAQs that are posted on. It's called the California Civil Rights Department. So if you just Google Civil Rights Department pay data reporting, those FAQs are really helpful. California, as part of this law, also provides templates. I'm sure some of you have used those, which have been enhanced. They now, if you hover over a particular entry, it'll explain what you need to include in that box or in that disclosure, in that report. So the significant thing here is the breadth of the statute. At least one payroll or contracted employee in California is enough, even if it's a remote employee, even if it's hired through what the California calls a labor contractor. I always call them staffing companies, but the terminology in the law is labor contractor. And under this law, employers are required to group employees by each unique combination of job classifications. And Tracy will get into a little bit more: pay band, race, ethnicity, gender at the establishment. And you have to report on both mean and median hourly wages and total hours worked, and include remote employees or virtual workers in your pay data report. So I'll let Tracy cover mean and median. I had to go back to my statistics class to figure out what those were. But again, the FAQs are invaluable. I always wondered what my California tax dollars were going to, and now I know at least something was used productively, because the FAQs are about 20 pages and answer numerous questions about who do you report on, how do you report hours, how do you handle salaried exempt employees. A lot of detail there. So again, I encourage you to read that, especially if this is your role. Actually raised a question for Tracy. I read in the FAQs, there's something about, they refer to a federal proxy, and California says the employer can use the federal proxy for calculating the hours worked by exempt employees who do not keep records of their hours. Can you speak to a little bit about that, Tracy, the federal proxy?
The federal proxy say that again, Tyler.
For exempt employees, so they're not tracking their hours, and you want to come up with an hourly wage, mean and median. How do you estimate, or how do you determine the hours worked by exempt employees?
Well, usually at the federal level, we tend to assume it's a 40-hour work week. But what's really nice about the California materials is they provide an incredible amount of templates and instructions on those templates, and then other instructions. They explain the calculations. It's very detailed. It's a very tedious report to compile, but you have the information that you need to compile it, which is a nice thing.
Yeah, and the FAQs kind of echo what you said there. They CRD, which is the acronym for Civil Rights Division, it used to be called the California Fair Employment and Housing Agency. So now it's called CRD. CRD expects the employer to make a reasonable estimation based on available information. A reasonable estimation may be 8 hours per day for a full-time employee and 4 hours per day for a part-time exempt employee. So consistent with what Tracy was saying there. So that's the basics of the pay data reporting law. What employees are included must include, the report must include employees who are assigned to work to a California quote establishment or who work in California, even if they're reporting to an establishment in New York or Arizona or Illinois. So you have it both ways. So if an employee touches California, either they're working from California, even remotely, or if they're reporting to another state, but they're physically doing the work in California, they should be included in the report. The report also includes both what the law calls payroll employees, W-2 employees, and also labor contractor employees, in other words, staffing company employees, identified in what's called a snapshot period. And I know Tracy's going to cover that. That's borrowed, I think, from the OFCCP EEO1 reports. But you're basically looking at October to December, a pay period in which you do the quote snapshot of data. The report must identify the number of entirely remote employees per group, the number of employees that don't work remotely, number of remote employees located within California, and also outside of California. All of those would be potentially included in the pay data report. This law is at the government code. It's where you find the discrimination, anti-discrimination laws, 12960, a little bit later in that government code. Again, borrows from the EEO1 survey reports, the snapshot period. There are 10 specific job classifications used, and it's also patterned after the EEO. And I did have a question, Tracy, about that. I was looking at the different job classifications. I was trying to figure out where I would fit. And one of the 10 is called operatives. And I don't know what operatives mean, but I like it. I like being an operative. That sounds like a kind of a man of mystery, an operative. So what is an operative? And the other ones are pretty clear about what they mean. What does operative mean?
Well, I think if you were going to man of mystery, I'm assuming espionage there. I think that would more be a professional. But operative actually is a classification for semi-skilled labor. So you have your craft workers who are highly skilled, and then you have, and they could be your construction type workers working on major construction, and then you have your semi-skilled workers. Many times we see they would be operating machines in factories. So that's an operative.
Good to know. Good to know. You're right. I'm not an operative. But anyway, there's 10 specific job classifications. The report must include gender, race, and ethnicity classifications. In the past, in 2022, for example, calendar year 2022, employers were allowed to report unknown, both for payroll employees and also for temps, staffing company employees. That's no longer permitted under California law. So in that situation, at least California recommends a question that the employees self-identify. And of course, California is worried about any kind of retaliation. It's completely voluntary. So in the FAQs, there's a sample disclosure that should be sent to employees. And, when in doubt, I would use the government's template. And I would use that one to say they're asking the employees to self-identify gender, race, ethnicity. Tracy has a lot of experience with these pay audits and reporting. What percentage of employees, in your experience, Tracy, actually do self-identify?
It really varies, but it's never 100%, right? Sometimes it's 30%. So the question becomes, what do you do? It is you all have to report the gender and race on the EEO1. So you should have that. You can get it from other employment records, of course, that you have, even using, for gender, you can even, many people use pronouns and put that on their emails. So you have that's the type of information you can look to, as well as more traditional employment records. However, if you don't have any of that, of course, you can default to visual observation. And I think there's something particular. What was it in the California law using visual?
I was reading in the FAQs that the government says you can do it by observation, but they say that CRD encourages employers to utilize the clarifying remarks field to state they have done so using observation, stating as an example, quote, the race, ethnicity of number of employees in this employee grouping is being reported based on observer perception. So that's something to consider when you're reporting, and you can no longer say unknown. California also recognizes 3 categories: male, female, and non-binary. So that is part of the reporting obligation. And there's a definition of establishment. It's basically an economic unit that produces goods or services. That's an establishment. Could be an office, could be a facilities, could be a sales office, probably not a remote, single person office, home office. But everything else, virtually everything else, would be considered an establishment under the law. There's some other differences with the new law. The biggest one is, only one hired worker in California can trigger the obligations. Regardless of the number of establishments, employers submit only one of each applicable report. So one on your own employees' payroll employee report, and a separate one on your staffing company's labor contractor employee report. And if there are multiple staffing companies used, they must be separately identified within the labor contractor employee report. And just kind of thinking about this, the law requires not only the employer, the client employer, but the staffing company to comply with these obligations. So in your staffing agreements, you might want to include language that makes it the burden of the staffing company, the labor contractor, to provide that data, maybe by a date certain. So by January 15 of each calendar year, the staffing company, whether it's Kelly Services, Manpower, the names, Aerotech, to put that in the agreement. You might also consider indemnification language. So if the contractor, the temp agency doesn't do what they're supposed to do, that the employer would have some recourse to get their money back. And I will also add that CRD is now going after employers that have not complied with the pay data reporting law. There was in the FAQs, there's a link to a recent settlement, $100,000 against a healthcare. Actually, it was a staffing company that didn't comply with the pay data reporting law. So we don't like to scare employers. But these agencies, they have resources apparently, and they are aggressively going after non-compliance. There's 12 pay bands provided. They start at $19,239 and under. The top one is $235,200 and over. Those are the 12 bands. The employer can use the W-2 box to identify which pay band they should be in for the snapshot. And the report, the data you can also rely on the W-2 box 5 for the prior calendar year for the pay band to include in the snapshot period. I mentioned earlier, it's not just the client, but also the employer client's staffing company that has to provide the necessary data, and workers hired through the labor contractor. So employers with fewer than 100 employees that are affiliated with one or more entities that employ a total of 100 employees may also need to file a pay data report if it's an integrated enterprise. And that's probably a separate webinar on what's an integrated enterprise. There's a lot of uncertainty in the law right now. The NLRB had a rule that basically everybody was a joint employer. That was struck down by Texas District Court, and it's on appeal. But that's another area that's been expanding. The holding the both the client employer and the staffing company liable as joint employers. In California, we have a relatively new labor code provision 2810.3, which attempts to make the staffing company and the client employer joint employers, and you can't shift the risk to the staffing company, at least under this California law. Another thing, this is all done electronically, so you can go to the CRD pay reporting portal. Tracy mentioned the templates are very helpful. They've now enhanced it, so if you hover over something, it'll show what you're supposed to do. And Tracy's right, it's super tedious. It's good for detail-oriented people. It's not rocket science, but it is tedious to complete and comply with these the pay data report. Also wanted to just briefly address the Equal Pay Act has been around for a while, but it's been expanded. It covers virtually all employees in California, and it prohibits pay discrimination based on gender, but also now includes race and ethnicity. Not surprisingly, prohibits employers from paying wage rates differently to those in a different gender or race or ethnicity who are performing substantially similar work when viewed as a composite of skill, effort, and responsibility and performed under similar working conditions. The law and the statutes and the case law have over time narrowed what employer burden is to show substantially similar work. And I think in the old days, employers could say, well, this person had, 2 more years of seniority, we paid them 10,000 more. I think those are going to be more scrutinized now, both by agencies and by court, at whether it's really substantially similar work. And it's also very similar, if not indistinguishable, from equal work under the federal Equal Protection Act, EPA. So this law, a plaintiff's lawyer will compare the pay of their client with somebody of an opposite gender, opposite race or ethnicity for doing the same job, and that would be a violation. These FAQs are from the Labor Commissioner, DLSE, specifically to the California Amended Equal Pay Act, and it defines what work, and it's a little bit circular, but work that is mostly similar in skill, efforts, responsibility, and performed in similar working conditions. There's a little bit of guidance there for employers in determining whether it's substantially similar work. And again, the trend is going to be to hold employers to the proof that it really is substantially similar work or not. The CEPA also has recognized affirmative defenses justifying pay disparities. You can see them there, and they've been around in the law for a long time. The BFOQ, I know that's been litigated like back to the 70s, a bona fide factor other than sex, race, or ethnicity. So there's a lot of case law on this historically, but I think the trend is to narrow those affirmative defenses and really hold employers to the proof that it really is merit or it really is seniority, and it justifies the pay disparity. Now, with that, I'm going to turn it over to Tracy to talk about federal contractors.
Thanks, Tyler, for that update on California. And yes, we are now going to talk about federal contractors and their obligations with regard to compensation practices. Before we do so, though, we have our first poll question. How would you describe your interest in today's webinar topic? Are you A, California employer, B, a federal contractor, C, both a California employer and a federal contractor, or D, none of the above? If you all will submit your answers, we can take a look and see who's in our audience today. Thank you. Okay, we've we've got about 41%. Excellent. Thank you all. Let's see. Okay, Tyler, we have 34% of our audience today is California employers, and 37% are both a California employer and a federal contractor. So they have a heightened burden. We have 8% are only federal contractors. Well, thank you all for your answers there. That's helpful to know. And thank you for attending. Okay, so who is a federal contractor? Well, if you're in the audience and you are a federal contractor, I'm sure you're aware of this, but a federal contractor is an entity that holds a prime or direct contract with the federal government, or is an entity that holds a subcontract for goods and services necessary to the performance of a direct contract with the federal government. Federal contractors are regulated by the OFCCP, which I mentioned earlier is the Office of Federal Contract Compliance Programs. And the OFCCP enforces 3 civil rights laws. Just briefly, those laws are Executive Order 11246, which prohibits discrimination against females and minorities. It is Section 503 of the Rehabilitation Act, which prohibits discrimination against individuals with disabilities. And it's the Vietnam-era Veterans Readjustment Assistance Act, which prohibits discrimination against 4 types of veterans referred to as protected veterans. Now, in order for these laws to apply, of course, there are jurisdictional thresholds, both based on employee count and the amount of the federal contract. If you're with regard to supply and service contractors, which are defined as any federal contractor other than a construction contractor, then the jurisdictional thresholds are fairly low. If you have 50 or more employees and a single contract of at least 50,000 or more, then the federal contractor is subject to the requirements of Executive Order 11246 and Section 503 of the Rehabilitation Act. If the federal contractor has a single contract of 150,000 or more, and of course 50 or more employees, then the federal contractor is also subject to the requirements under VEVRA. So as a federal contractor, why is it important? It's important because you have heightened obligations when it comes to employment practices and the civil rights laws. Federal contractors have certain heightened record-keeping requirements, posting requirements. Of course, you have to prepare written affirmative action plans and all the statistical reports that are required to maintain and prepare an affirmative action plan. And importantly, you are subject to an audit, or what's called a compliance evaluation, which is an audit by the OFCCP. Okay. Now, the specific regulation regarding compensation practices that we'll discuss today is Title 41 CFR 60-2.17b, and it's on the screen, and it is remarkably short for its impact. And it's valuable just to go over it quickly. Title 41 60-2.17b requires an in-depth analysis of total employment processes to identify impediments to equal employment opportunity, including, and this is the subsection that addresses compensation, including an obligation to evaluate compensation systems to proactively identify pay disparities based on gender, race, and ethnicity. It's important to note at the outset what that regulation does not say. It does not specifically mention the method of analyzing your compensation. There is no language in there that says you have to prepare a pay analysis or a compensation analysis. But remember, the obligation on federal contractors is heightened, right? And you have an obligation to take affirmative steps to ensure that discrimination is not occurring in your hiring and recruitment practices, including your compensation practices. So, and this regulation, as many of you know, the OFCCP's interpretation of the regulation has been evolving over a number of years. And their most recent interpretation was released in 2022 in revised Directive 2022-01 entitled Advancing Pay Equity Through Compensation Analysis. And it is a directive which as many of you know, are aware of, it is not legally binding. It is actually OFCCP's instruction to its own employees on how to enforce their regulations. But it does give us, as the regulated contractors, insight into their methodology. So it explains that the OFCCP does have the authority to review your data, your pay data, during a desk audit to ensure that you are complying with with the obligation to root out any pay disparities that are unlawful, meaning they're based on gender, race, and ethnicity, and to prepare a pay analysis. Now, it's a lengthy directive. We won't go over the entire directive, but there are some important takeaways. When you produce documentation to the OFCCP, they will not require production of documentation that contains attorney-client communications or work product. However, they also take the position that if you prepare documentation as part of your regulatory obligations, that documentation is inherently not privileged. Further, if the federal contractor asserts privilege over their compensation analysis and they cannot provide other documentation to substantiate that they have complied with their obligation under the regulation 2.1723, then the OFCCP will find that they have not satisfied their obligation. So the question becomes, what type of documentation will OFCCP accept to establish that you have met your compliance obligations with regard to preparing a compensation analysis? And they provide 3 alternative means for you to do so. You can redact your privileged version and provide them with a redacted version of your pay analysis. You can run a completely separate pay analysis that does not contain any attorney-client privileged information, so long as it meets certain minimum requirements, and provide them with that analysis. Or the final way, which they recommend, is to provide a detailed affidavit that requires specific minimum information relating to the pay analysis, and we'll address that within the next couple of slides. So, and this is important because in the context of an audit, so as far as your pay analysis, because that is when you will be required to prove that you have complied with your obligation to identify pay disparities that are unlawful and to remedy those pay disparities. So it's not surprising that in 2023, when the OFCCP released the revised scheduling letter and itemized listing, that the provisions in the directive found their way into the revised scheduling letter. And a scheduling letter and itemized listing, for those of you who have been fortunate enough not to experience an OFCCP audit, is the letter that the OFCCP sends out to federal contractors when the federal contractor has been selected for an audit. The federal contractors, once they receive that letter, they have 30 days to respond and provide all the documentation and all the data that is requested. There are 26 items, they call them items, in the scheduling letter and itemized listing that has to be responded to, and multiple subparts under most of those items. Items 19 and 22 are the 2 items in the scheduling letter and itemized listing that refer to compensation. Item 19 requires federal contractors to provide 2 years based on AAP years, the current AAP year and the previous AAP year, of employee level data. So for each employee, you'll provide census data first, which is, when I say census data, I'm just referring to the employee name, the date of hire, the demographics, gender, race, ethnicity, the EEO codes, job group that they're in, and the job title and department. And you will be reporting on all of your employees. In addition, under item 19, I believe it's the second paragraph of item 19, it states that it prefaces the information that it's required to be submitted with the words, if maintained by the federal contractor. For each employee, you're providing base pay and salary hours worked in a typical work week, as well as any other adjustments to pay that have occurred over the relevant AAP period, whether they're bonuses, commissions, overtime. It's all required to be reported. In addition to actual pay information, the OFCCP is gathering information now on those factors that influence your pay decisions. For each employee, remember this is for each employee. So we're talking experience, education, time in position, time with the company, perhaps salary band or grade, and performance ratings. And finally, the third point, the third item requested under item 19 is documentation related to policies and compensation practices, which could be anything. It could be your handbook policies relating to compensation. So make sure your handbook policies are concise, to the point, and they say, and that they're not, they reflect what is actually occurring, and they're not aspirational. Or they could be training. The documentation could be training programs that you provide. It could be even offer letters. So those are it's a pretty broad array of documentation that they're asking. Let's
Tracy,
and reflect. Yeah.
Tracy, sorry, I was just going to say, I know you're on a roll there, but we've had a few questions come up, some really good questions, and I thought I'd throw one of them to you.
Sure.
So a couple of people have asked if they have employees in another country, India or Europe, either under the California pay reporting law or under EEO1, are they required to include those in the report?
Right. So under federal contractor, with respect to federal contractors, you're talking about that, and you've got a situation where, say, you have employees that are in another country and they're reporting to, they're on the payroll of the United States entity, and they're reporting back to the United States. They would likely be in your AAP and reported, and then you would be if they're in your AAP, right? Then you're having to report on pay. There's a lot of different. This is a huge area and it's kind of complicated. It gets even more complicated as people are sitting in different offices, or maybe they're remote, and you have to figure out, where they sit, who are they reporting to, where is their manager. So it's a complicated analysis.
Yeah,
But,
I just quickly looked over the California FAQs, and they speak about California's outside of California, but they don't talk about outside of the U.S. It might just be something that hasn't been addressed yet. Like in your hypo, if somebody is in India but they're reporting to a U.S. parent, there may be an obligation to report on them. Another just question which I saw here was if you have a employee that's going to be relocating to California for a year, and the employer would like to engage that person as an independent contractor. So at least the California pay transparency reporting law excludes independent contractors, bona fide independent contractors, 1099s. But as we all know, it's gotten a lot harder to have bona fide independent contractors in California. It's almost like we kept complaining for about 30 years that it was a gray area. And then the California Supreme Court said it's no longer gray. You can't have any more independent contractors under California law. That's the ABC test. So to Brian's question, I would be more worried about a potential, misclassification claim there, where all of a sudden you're back into a reporting obligation and a misclassification claim. Sorry, Tracy, I just wanted to answer a couple of those while we have them up.
No, that's fine. Gives me a little bit of a breather there. Okay, so we were talking about item 19, and I was going to make a couple of observations. The OFCCP's revised scheduling letter increased the amount of data you have to provide. It used to be 1 year of payroll data based on the current AAP year. Now it's 2. That gives them 2 years of pay data, and to incorporate into their statistical analysis, and to look at pay disparities that are persisting over time too. So there is that. Secondly, this language, if maintained by the federal contractor, it is likely, and I've seen it, I've already seen this occur, that you may not be maintaining information for each employee on factors that influence pay decisions. And that really that statement sort of hinges on the word, what does maintain mean? The OFCCP doesn't identify or define maintain, but this is information that you are producing within 30 days. So if you don't have your factors that influence pay, we'll call them, in a digitized and organized, if you don't maintain them in an organized and digitized manner, you likely are not going to be able to provide that information to them. In that case, we are recommending that you state to the OFCCP in response to this item 19 that yes, we do. There are a number of factors that we consider when we make our pay decisions, such as, and you can list those factors, but say that we don't maintain documentation regarding those factors. Another observation I'd like to make is that whatever information you do submit, go over it more than once and make sure that it's accurate, because what the OFCCP is doing and what they said they would do in the 2022 directive is that they will take your pay data and they will run their own pay analysis. They have stated that their preferred method is a multilinear regression analysis, and they will be looking for pay disparities based on that are unexplained, that are based, and they will assume that they're based on gender, race, or ethnicity. And you'll have to show that they are not. Going on to the next item that addresses compensation, item 22 of the itemized listing. If you're in a desk audit, you'll be responding to item 22, which requires that you provide documentation of your compensation analysis. What type of documentation would you need to provide? At a minimum, you will need to provide documentation that provides the date that you ran your compensation analysis, the method used, whether it's a regression analysis of some sort or a rank and sum analysis or a cohort analysis is even possible. You will have to define for them the number of groups of employees, types of employees that were included and excluded in that analysis, as well as the types of compensation and whether they were analyzed and whether those compensation was combined with other types of compensation or analyzed separately. And of course, you have to confirm that the analysis was based on race, gender, and ethnicity, or took that into consideration. Okay, Tyler, this is our second poll question.
Okay, so what is the scope of the pay analysis performed in your organization? This is totally anonymous, right, Tracy? They don't.
Yes.
Interested to hear how you perform these pay analysis, and we'll wait a few minutes to see what people do. And it's okay to say I have no idea. It's not my role. While we're waiting for those results, Tracy, how complicated is a pay analysis? Like if a client called you and said, we have 100 employees, let's say in California and Illinois combined, what does that look like for the company to do a pay analysis?
Right. Well, that's actually the next section that we're going to get into, but it's not an easy endeavor, right? It takes time because first you have to decide, there's a number of preliminary factors that you decide before you run your analysis. Then you gather your data, you run your analysis, and then you have to go through those pay disparities and look for the legitimate reasons. So it's not an easy endeavor. It takes time. If you're running this as a federal contractor, when you get your at the time you get your scheduling letter, and that's the first time you're running it, that makes life very difficult. Looks like we have some answers here to the poll question, Tyler. It looks like 34% of attendees do evaluate pay on a regular basis. 23% analyze parts of their workforce, which is fine, on regular intervals when possible. 34% have no idea, and 8% have said that they have not previously conducted a pay analysis. Well, that's interesting. Okay, should we move on? Thank you all for participating. Okay, we started to talk about this while we were waiting for the poll. Probably the most important issue that arises when you're considering a pay analysis is the issue of how to group your employees for the purpose of comparing whether individuals of a non-protected classification are treated more favorably than those of a protected classification, right? And it's actually Title VII, the law, that provides you with that standard. And you're comparing similarly situated employees. Say that 3 times quickly. Similarly situated employees, and it's a loose definition. It takes into consideration all objective factors. And the way the courts characterize it is that similarly situated employees are able to perform all the material or essential functions of the job, right? So if you have 2 individuals and the essential functions of their job are the same except for one essential function, then those 2 people are not similarly situated. They're not comparable under Title VII standard. So the law provides the standard, and then it's up to the HR or usually the HR team to determine who in their organization, which employees are comparable. And it's based on, your job description, which will have information such as minimum qualifications, and it's based on your knowledge of what the duties and responsibilities are for each of the jobs in your organization. Once you've grouped your employees, you will then run your pay analysis, decide what type of analysis best fits your data. Once you run your statistical or analysis, whatever analysis that you're running, you will there will be disparities in pay within each group. You will then have to investigate or go back to you, the HR team, and hiring managers to determine why individuals' pay differs within the group of these similarly situated employees. So if you have a group of 5 individuals who all have the same job title and you've determined that these are similarly situated employees based on your grouping, and there's fluctuations in pay among the men and the women or the individuals of different races, then you're going to need to be able to, based on your records, to identify why one of the individuals received more of a salary adjustment than another individual. So you're identifying the legitimate non-discriminatory reasons for those pay disparities, and those are your affirmative defenses. Then you're going to want to document the reasons that justified the pay differences, right? So that you have that. And as Tyler will talk about, you want to do this exercise under privilege. Once you've identified all your pay disparities and you've done your investigation, you'll have to develop a plan of action, I call it. And that's if you have any pay disparities that remain unexplained, then they are liabilities if you don't address them, or potential liabilities, I should say. You address how they will be remedied, This is also a great time for you to review your compensation policy and tweak it as you need to. Make sure that you train your managers and your HR team, anyone who has responsibility with respect to pay decisions, to make sure that the compensation policy is being applied consistently. And then it's also a perfect time for you to make sure that there is documentation that's occurring. Many times in the workday, people, you're making salary adjustments. Perhaps you're just entering it into your electronic system, and not enough information is, you give us an increase in salary. It's not an across the board increase in salary, but what's the basis for it? That needs to be somehow incorporated into your system. Okay, and Tyler is going to talk about this very important idea of doing a privilege pay analysis and the considerations and best practices around maintaining that privilege. Tyler, it's all yours.
Thank you, Tracy. So thank you for sending all the questions. I see a lot of really good questions. We will promise to send you separately answers to all those. Just in the interest of time, we're going to move on here. I just saw one that I wanted to address. Somebody asked if you only have remote employees in California, how do you report them if they aren't in an establishment? So just to clarify, the report is through the online portal. So it doesn't matter if they're reporting to an establishment in California. If they're working in California, they would be included in your report, even if you don't have any establishment in California. So still obligated to report that. So this, a lot of you on the call, some of you are lawyers, HR, that you know how important the attorney-client privilege is. And this has to do with how do we fix, if we need to fix stuff and still maintain the privilege. How do we do a pay analysis without creating a roadmap for plaintiffs' lawyers to sue you on a class action? So it's important. Some of these things are common sense, but an in-house lawyer could be wearing a business hat. So if you're giving business advice as opposed to legal advice, that could waive the privilege, not invoke the privilege. Some of these things, as I say, are pretty basic. We recommend, and Tracy and I have been talking about this for a few months, that you consider doing a separate privileged audit where you can be a little more candid, the client, outside counsel, or internal counsel, and do that in parallel with maybe one that you're going to turn over to the government. So you don't have to worry later about redacting a bunch of stuff. And then whenever you produce something redacted, the government will say, well, we want to know what you redacted. So keeping a separate privileged and non-privileged pay analysis audit, I think, is a good idea. When you're creating the privileged audit, simple things like just every email should say protected by attorney-client privilege, privileged and confidential, label documents that this is sent or received for the purpose of getting legal advice. That's the definition of the privilege there. And you want to be obviously careful about waivers. So limiting the need to know who can have access to our privileged pay audit. Employers know that if you place the information at issue, the simple example is if you're sued for sexual harassment, you conduct an investigation and you use the workplace investigation as a defense, you've necessarily or impliedly, you've waived the privilege if that investigator was a lawyer. You put it at issue. So that's something to be mindful of here. What we're talking about is a separate audit, an analysis that would go to legal for the purpose of legal advice. So to keeping that completely separate from the non-privileged version. And there's some other simple steps. It's important to plan the audit and not just just do it seat of the pants, to create an outline, who's going to be involved, who's going to have access to it, what are the roles, and implement these protocols to make sure that the privilege is maintained throughout the compensation analysis. And this is more of what Tracy was saying earlier. once we find the disparity in pay between employees of the opposite gender or race or ethnicity, we want to carefully document in the non-privileged version why there is that disparity. And if it's not explainable by seniority, skill, experience, et cetera, tenure, then remedy it, and fixing it promptly is good practice. That also can be done under the privileged audits, investigation or audit, so that we wouldn't turn that over to the government or plaintiffs' lawyers. And that is one way to just keep this privilege sacred and not have our secrets about pay analysis revealed to a government auditor. And I know we're at our witching hour here. Thank you all very much for attending. As we said at the outset, we will get to all of your questions. I saw a number of really good questions. Some of them may have to have us go to hit the books and research. Or Tracy might know off the top of her head, but we will get back to you on each one of those questions. Thank you all for attending, and feel free to email us with any other questions.
Right. And remember, the program's been approved for legal education hours. To report your hours, click on that CEU icon at the bottom. Also, you'll get a certificate of attendance for including, which will be emailed to you, I believe, tomorrow, along with the recording of the webinars for you to share. And then if you can, please complete our short survey. We do appreciate your feedback. And if you have any suggestions for us for future programs, please include those. Thank you all. Have a wonderful day and hope to see you all soon.